Hey everyone, welcome back to the channel. Today, we're following the latest chapter in the case of a sovereign citizen I've been covering for the past few months. He's now facing a DUI charge and has decided to represent himself in a bench trial. If you've seen his previous court appearances, you probably already know where this is headed, but it still manages to get even more chaotic. We'll begin with his first two hearings, move on to the third, and then break down the biggest moments from the trial. Let's jump right in.
Can you hear me?
Yes, what's your name, sir?
Yes, I'm here to make a special appearance.
What's your name, sir? Can you tell me your name?
Uh, Don Lyons.
Okay, we're on 2508, scene 2346, State v. Don Lyons, who is here today via Zoom, states again present. See, advise at your initial hearing, you wanted to proceed pro se, without an attorney. Is that still your intent today, sir?
Say it again.
Is it still your intent to go forward without an attorney?
Yes, sir.
Okay, so we have two options today. You can either ask for some more time to either put together a defense or hire counsel or talk to the state about any potential resolution, or we can simply set this matter for a bench trial. Which of those two options would you like today, sir?
I would need request a continuance to work on my defense.
Any objection? I say no objection. Okay. Looking to age of the case, that's fine. So I'm going to reset this for December 22nd at 8:30. So Mr. Lyons, we'll see you back here on that date and time.
Say it again. You said
December 22nd at 8:30.
December 22nd. All right, thank you.
Yep. All right, so we're on 2508 CM 2346. State v. Don Lyons, who's here today in person. State is also present. So we're here. All right, so the state has filed one additional charge. And it's for count 3 operating vehicle with an ACE of 0.15 or more. The state alleges that on about July 21st of this year in Montgomery County, state of Indiana, you did operate a vehicle with an alcohol concentration equivalent to at least 1,500ths of a gram of alcohol per 100 milliliters of your blood. Class A misdemeanor carries with it a penalty from 0 to 365 days, Montgomery County Jail, and a fine of up to $5,000. Do you understand the allegations against you and the possible penalties?
I'm here to make a special appearance, and I had sent a motion.
Yeah, so that was filed this morning.
A motion to get this dismissed.
Okay, since that was just filed today, I don't even know if the state's received a copy of that. I'm not going to set that for hearing today, but what we'll do is we'll set this for another pretrial conference, and that we can address that motion at that point. We'll do that. Set that, say January 26th at 9:30.
What date is that?
January 26th.
What's that date? Whoa. No mistake.
Okay, we're gonna do the 28th.
Yeah, 28th.
Okay, we'll say January 28th at 10 a.m.
Yes, sir.
All right, so we'll see you back here on the date and time, sir.
All right, thank you.
Thank you.
So, as expected, we get the usual routine, challenging the court's jurisdiction, claiming a special appearance, and making arguments that carry no legal weight. With all of that out of the way, let's move on to his third court appearance.
Mr. Lyons, can you hear me?
Yes, I hear you now.
Okay, we can get your face on camera there.
That's what I'm trying to do.
There we go. This is 2508 CM 2346, State v. Don Lyons, who's here today via Zoom. State's here in the courtroom. We're set for a pretrial conference. Lyons, the first question is, you've been appearing pro se. Is that still your intent, or do you intend on hiring counsel, or do you want me to consider appointing an attorney for you?
No.
Okay. So I'm going to advise you, just in proceeding pro se, you are going to be held to the same standard as if you were an attorney. You're going to be expected to understand the rules of trial procedure, rules of evidence, rules of criminal procedure. Do you understand all that if you go forward without an attorney?
Yes.
Okay, so I think
I had wrote an affidavit. No, I'm still waiting for a response.
okay, and I see that affidavit, and I think we received that the date of our last hearing. It doesn't look
Correct.
to doesn't make any specific requests. It's a request for dismissal of charges, and this does not comply with Criminal Rule 2.7. It's also not an appropriate motion to suppress.
I have to object to that.
Understood. So what I'm going to do is I'm just going to set this matter for a bench trial. Set that April 1st at 1:30. So that's going to be the court's order for today. This will be set for a bench trial, April 1st at 1:30. And all parties are going to be ordered to be here in person on that date.
April 1st, what time?
1:30 p.m., sir.
All right, thank you.
So, nothing significant happened there. Just another reminder that he doesn't really understand how the legal process works. Unfortunately for him, things only go downhill from there. As we move into the bench trial, he makes very little effort to challenge the testimony presented by the prosecution's witnesses. We'll jump straight to the trial itself. I'm going to skip the direct examination of the arresting officer since it's mostly routine procedural testimony. Instead, we'll focus on the cross-examinations, which turn into a textbook example of what not to do when you're representing yourself in court.
We're making a special appearance.
Hold on, I'm going to call the case. It says 2508 CM 2346, State v. Don Lyons. It's here today in person. State's President and Prosecutor Tyler Trulock. Set today for a bench trial on counts 2 and 3. Count 1 was previously dismissed. Michelle, I just say you wanted to note something before we begin.
Yes, I'm here for make a special appearance.
Okay, and what do you mean by that?
Like I know I'm here to represent myself and challenge the jurisdiction.
What's your request to challenge the jurisdiction?
The OWI
Okay.
that was there that they had a warrant for to take my body to it, but I don't recall seeing that one.
The bench trial begins with the defendant immediately declaring that he is making a special appearance as the court calls the case of State versus Don Lyons. The judge notes that the trial will proceed on counts 2 and 3, as count 1 has already been dismissed, while Deputy Prosecutor Tyler Trulock appears for the state. When the judge asks what he means by a special appearance, the defendant explains that he is representing himself and is appearing only to challenge the court's jurisdiction. He then shifts to the OWI case, claiming that law enforcement said they had a warrant authorizing them to take him into custody, but insists he has never been shown such a warrant, arguing that this somehow calls the court's authority into question.
Okay, well, the time for challenging any of the procedural issues or evidentiary issues has come and gone. Today we're set for a trial on the facts of matter. So if you want issues with the evidence being introduced as it's being introduced, you can make appropriate objections. We're going to go forward today. State, you ready to proceed?
Yes, sir.
Go ahead.
Your Honor, the state calls Trooper Devin Walsh.
Any questions, Mr. Lyons?
Yes. You what side of the car you was on when you first said you had smelled? When you had first asked, was y'all smoking any marijuana in the car?
Passenger side.
And then right after that, you had said you had smelled alcohol, right?
Yes.
It was on the passenger side,
So alcohol on the passenger side and on the driver's side.
but she was on the passenger side first, right, when you said it, right?
Yeah.
Alright, so when you came to the driver's side, and I got out the car and I told you I refuse to take the test. We went to the hospital. How can I say? When did you present me the warrant?
I read you the warrant right before we drew your blood. Like I'm supposed to.
This is on file.
It's on camera.
Is it on file though?
They have my body camera. They have it all.
On file?
So you have to ask questions about this.
So you don't know if it's on file or not.
They have all my body camera, dash camera,
You don't know.
all that. I sent it to them, so I would assume so.
You said the warrant was signed around 6:21.
Well, it was around 6:21, so I'd read you the warrant that I did. So I did read it to you right before the blood draw happened.
You have any proof of the audio?
Audio, it's on my body camera. It's on all the time.
I don't see it. And I see it. But I really don't recall. And if there was a warrant, you know what I'm saying?
It was
Go
attached.
about it like that. But
My
I
report's
don't recall no more.
I'm sure to say that.
Like,
You have any questions?
Like I was on, I do, but not right, not.
Anything up that state? No, you can step down, sir.
You think maybe you don't remember the warrant because you were too drunk to remember anything.
Ms. Dominguez, is there anything else you'd like the court to know at this point?
No.
Thank you, ma'am.
Mr. Lyons, do you have any questions for this witness?
Yes. I know it was a while ago, but you know around the time that they took my blood?
I don't remember.
That's all I had.
Anything up that state?
No,
You can step down, ma'am.
Okay,
Mr. Newtown, is there anything else you'd like the court to know at this point?
do not believe so.
Thank you.
Do you have any questions, Mr. Lyons?
No, sir.
You can step down, ma'am.
This is the only witness the defendant makes any real effort to cross-examine, and even then he fixates almost entirely on whether a physical warrant was read to him while he was intoxicated and receiving treatment at the hospital. He never challenges the legality of the investigation, the probable cause for the blood draw, or the officer's procedures, areas that a defense attorney would typically scrutinize. The state then calls the hospital nurse and the forensic lab technician who tested his blood samples. Their testimony moves quickly, and the defendant's cross-examinations are brief, unfocused, and ultimately fail to raise any meaningful challenge to the evidence presented against him.
Mr. Lyons, do you have any evidence to present?
And y'all didn't give me the motion of discovery. I was thinking y'all was gonna send it to me. I didn't know I had to buy for it. That's my ignorance. I don't have no evidence. No, sir.
So today's trial, the state needed to carry their burden, need to prove beyond a reasonable doubt on count 2 that Mr. Lyons had operated a vehicle while intoxicated, and on count 3 that it operated with an ACE of 0.15 or above. State has proven that he was operating a vehicle, and through the expert testimony has proven both counts 2 and 3 beyond a reasonable doubt. We can proceed to sentencing. Mr. Lyons, is there anything you'd like me to consider on sentencing?
My grand got to get back home today, and I really don't remember or recall them showing me that warrant in that hospital. I kind of remember that night for the most part, but I was hoping to see the audio or see the documents of timing of the warrant. What they were presenting, that'd be nice.
Any I'm sensing state.
Just a few questions, Your Honor. Mr. Lyons, are you currently employed?
Yes, sir.
Where do you work?
Work at the train station right now, Earth Point.
Okay. Is that a full-time job?
Yes, sir. Now it is. I was working two at first.
Okay. And where do you live?
Well,
Okay. Louisville, Kentucky.
yes, sir.
Mr. Lyons, do you have any criminal history of any kind?
Yeah, look, right. Like the criminal history.
Yes.
I got a little record. Mainly tried. Yeah, but
So what have you been convicted of criminally?
that's some marijuana. Some marijuana. Pretty much.
Is it possession of marijuana?
Yeah, that's
Okay. Is that the only thing you've been convicted of?
I can think of right now.
Okay. No previous operating while intoxicated convictions, anything like
No,
that?
it's my first time. The first time.
Thank you, sir.
Let's just hope it's also your last time. So, as the judge said, he was found guilty based on the evidence and the expert testimony that was unrefuted. Now, let's hear what his unexpected sentence is going to be.
Any other evidence from the state?
No.
What's the state's request on sentence today?
Your Honor, state doesn't have any reason to doubt what Mr. Lyons said about this being his first operating while intoxicated conviction. The state is concerned by the fact that Mr. Lyons was operating a vehicle with an alcohol concentration above 0.15. However, it does not appear that Mr. Lyons has many, if any, ties to this community. So the state's first inclination as to sentencing would be to ask for just a short executed sentence for him to be done with this case. If the court's not inclined to do that, the state would just request a 365-day sentence suspended to probation, as well as a reasonable fine and license suspension. Thank you, Your Honor.
So, yeah, those are my things to consider. Understandably, if I would put you on probation, it'd be a misdemeanor probation that is difficult to transfer across state lines, and that's going to be very difficult to have done with you living in Louisville, Kentucky. So what the court's going to do today, given your lack of criminal history, is I'm going to sentence you to 10 days in the Montgomery County Jail. That's 5 actual. So you've got credit for 1 actual day already when you were first arrested. So you're going to have 4 days remaining to do. So you're going to be taken into custody, placed in the custody of Montgomery County Jail today. You're going to be released 4 days from today. And there's going to be court costs of $189.50. And I'm not going to impose any additional fine. There's a $200 alcohol countermeasure fee. There's also going to be a 90-day license suspension that's going to go into effect tonight at midnight.
That's suspensions for the state of Indiana.
Yes.
Uh,
So I'm not sure how that transfers to Kentucky. That's going to be the order for today. It's going to be remanded in custody.
All right. So what about man, my granny though? She can't really see like that. I gotta help her get her.
Well, sir, you've known for quite some time that you were scheduled for trial today.
Yeah.
And so
Well,
plans you've made
Right.
are on you. So that's going to be the order for today.
I'll get out and go there.
And I will notify you have 30 days to file a notice of appeal if you want to appeal this decision.
Looks like Grandma will need to find another ride home. Cases like this are a reminder that when other people are counting on you, making responsible decisions matters. Choosing to ignore the law or relying on sovereign citizen arguments that have repeatedly failed in court usually only makes an already difficult situation worse. That wraps up today's video. It was a shorter case than usual, but there are plenty more courtroom moments like this on the way. If you enjoyed the video, be sure to leave a like. If not, you can always hit the dislike button. Either way, I'd love to hear your thoughts in the comments. And don't forget to subscribe and turn on notifications so you don't miss the next upload.